Hello everyone, and welcome to a new episode of the Space Law and Policy podcast series. I'm your Professor Glenn Torres-Spelliscy. Thanks for joining me. In this podcast, we prepare ourselves to discuss concepts of space law by focusing on general principles of international law. Space law is, after all, a part of international law, governed by the same principles that govern the interaction of states versus other states as well as states vis-a-vis individuals. So to understand both the impact and potential of space law, we must first understand the general principles that underlie international law. So let's talk about it. What are some general foundational concepts of international law, and how specifically might international law impact the future development of space law? Well, the purpose of international law, indeed the purpose of all law, is to establish what I call the reliability of expectations. What I mean is that the law is intended to provide actors, whether international or domestic, with reliable expectations with respect to how others in the system will behave. And in the same vein, it's designed to provide some means of redress when those others behave in contradiction to what is expected. As expectations of behavior change over time, so do laws. This is particularly true in the international legal sphere. But at its essence, that is what all law is, a way to order the world so that everyone has a reasonable understanding of how others in society will behave. Without that assurance, business transactions and indeed everyday life becomes much more difficult, and progress is stymied. So, if the law is about establishing reliable expectations as to how others will react, then it becomes really important to understand how a particular society wants its people to act, because that will determine which laws are adopted. Indeed, all law is simply an expression of the normative values in which it arises. For international law, this means that it's an expression of the geopolitical system in which it arises. This is particularly true in the realm of space law. The laws that currently govern space conduct reflect the political system in which they were created, a bipolar system of power. But more important from our perspective, a system of power that no longer exists, that has given rise to regulatory gaps that currently threaten to undermine our progress and development in space. So let's move on to talk about some basic concepts that serve as the foundation of international law. The first is the concept of sovereignty and its related principle of equality of states. Sovereignty is the rights and attributes a state possesses within its territory to the exclusion of all other states, and in its relations with all other states. It posits that each state is an equal player in the international system, with no state being superior to another under the law. As a result, it establishes that within a state's territory, the sovereign government is the only true authority, and that interference in the sovereignty of another state could potentially be a crime under international law. Now, as I discussed in the lecture book, this concept has undergone some developments, particularly in the last 100 years or so, and the international community has become more empowered to object to the domestic policies of other states if they could be said to violate certain core prohibitions, like those against genocide, crimes against humanity, and other massive human rights violations. Still, the concept of sovereignty remains at the heart of the international system. Now, the second foundational concept is that of an agreement, voluntarily made between states, and that agreement then is binding. This is known by the Latin phrase pacta sunt servanda, which translates simply to agreements must be kept. Now, there are two primary ways that an agreement can come into existence, and these are recognized in what is called the doctrine of sources. The doctrine is expressed in many different documents, including the Statute for the International Court of Justice. The first way an agreement between states is evidenced is through something explicit, a convention, a treaty. Treaties are considered to be the primary source of international law, and once a state agrees to the provisions of the treaty, it is understood to be legally binding on that state. Now, importantly, treaties only apply to the states that sign and ratify them, and there is a discussion in the lecture book about what that means. But for our purposes here, the general principle is that because each state is sovereign, it can only be legally bound by treaties that it has voluntarily agreed to. This is the same principle we see in domestic contract law. There has to be consent. Now, the second way an agreement can be evidenced under international law is through what we call an implicit understanding. And this is a little more difficult to understand, but it is born from the idea of international custom. A custom is held to be a general consistent practice of states, followed by them from a sense of legal obligation. The idea is simple. If almost every state, particularly those with vested interests in the topic, if almost every state is behaving in a particular manner over a long period of time because they believe there is a legal obligation to behave in that way, then the international system will deem there to be an implicit agreement amongst all states, such that the customary behavior becomes legally enforceable. In short, if states act like there is a binding legal principle, even if it has never been explicitly agreed to in a written document, the international legal system will enforce its existence. Now, because this is a system-wide principle, it applies to everyone in the system, except in a few circumstances, as I discuss in the lecture book. There is one additional source of law or type of law that is applicable with respect to the development of space law, and that is something called soft law. Soft law often reads nearly the same, but it comes from a source that is not binding. It is a normative expression, but the law does not require that its violation be rectified. Where do things like soft law come from? Well, from sources like the UN General Assembly resolutions, from industry standards and voluntary codes and guidelines. These are all normative expressions as to how international society wants states and other international parties to act, but they're not legally binding. Now, sometimes they are still effective because the breaking of these principles can bring about negative consequences from a political perspective, but legally, there are no repercussions for their violations. Well, that does it for this week's quick podcast. Join me next week for a new episode of the Space Law and Policy podcast series.